This is Stephen Bonfa, and we're going to talk a little bit about the probate process, what to go through. We have clients, unfortunately, especially over this last couple of years with COVID and such. This has become an issue, a lot of questions, concerns about what to do, what's the process like. So I figured I'd take this opportunity to share it with you. Okay, here we go. So let's start with some general terms. A probate proceeding. So when someone has a will and passes away, you have to have a probate proceeding. It's a filing of the documents with the court, and the court appoints an administrator, or a probate proceeding would be an executor. That is what a probate proceeding is. Another type of proceeding is called an administration. The only difference between a probate proceeding and an administration is that the administration does not have a will. So you're not filing an original will with the court, and then the rules of what we call intestate govern. So when you have a will and go through a probate proceeding, you're the person who decides what is going on and where you want your stuff to go to. While an administration, it is the government statute that determines where you want to go. But those are the two different types of proceedings. There are two types of property. There's probate property and non-probate property. Typically, I like to describe probate property as property that does not have a legal direction to go. So if you own a house with your spouse and it's held joint, or your cousin or your brother, and it's a joint with a right of survivorship, that is non-probate property. It does not have a legal direction to go. If the house is just in your name, then that would be probate property. There is no operation of law to make it go through. So probate property only has your name. It does not have a beneficiaries or a payable upon death clause. It's not held in a joint situation. Non-probate property is just the opposite. It's held jointly. It's held with the right of survivorship, and by operation of law, it will flow to someone else. The next is terms that we'll hear is testator or testatrix. A testator is the person who has a will. If it is the old way is gendered. A male is a testator, and a female is a testatrix. Same thing with an executor. An executor is the manager of the estate. It's an executor is named. If you have a will, you are the testator, testatrix. The executor is the person that you name to manage your estate and file the probate proceeding and do what they have to do. Is that an administrator or an administratrix is the exact same thing as an executor, except it's for an administration proceeding. So it's different names, but they have the same function. So you, as the person who writes the will, is a testator. The person who you nominate to manage your will and to make sure what you want happen in that document gets done is an executor, and the administrator is someone who steps forward to handle your estate when you don't have a will. So within that, there are some distinctions that you have to know. There's someone that's called a distributee. There's a legatee and a devicee. So a distributee, all of these are in fact beneficiaries. So the people that you name in the will and otherwise who would accept a share of what you have, or in an administration who was entitled by law to receive it. So that is what a distributee is. A distributee is someone who would take a share of your assets after you pass away, whether or not you had a will. These are people by law. They're also known as next of kin, sometimes you hear, or heirs at law. So that is what a distributee is. A legatee is a person who receives tangible personal property. So someone who in your will you say, hey, here is my wedding ring, or here's a cash gift, or something along those lines. It's just personal property. And cash gifts, clothes. So if you own a cow and you want to give a cow to someone, you are that person who you want to give it to is a legatee. And finally, you hear the words devicee. That is someone who receives real estate. So there was, back in the day, there were some real distinctions between these classes. It's gone away a little bit now, but essentially those are the technical names with regard to that. You'll have to know that who is a distributee, legalese, or a devicee when you do your probate filings. This is the types of documents and information that you need when you go to file a proceeding, whether it be a probate proceeding or an administration. You need the original death certificate. So that's an important document to have. You can get that through the funeral home is typically the easiest way. And I typically recommend clients get at least, be somewhere between 8 and 12 original death certificates, because you're going to be needing that to send to different things, and down the road it's always good to have a couple extra. You need the original will. The court is going to expect to receive the original. Whenever you do a will, only one original should be made, and that would have to go into the court when you pass away. I'll just say one other thing with regard to death certificates. There are two types of death certificates. There is the state death certificate and the city death certificate. The difference between the two is that state death certificate lists the cause of death. So if in COVID, FEMA was providing assistance with regard to burial and funeral, etc., you had to order the New York State death certificate. So anyway, we need to get the original. Well, there are ways of probating or going forward with the copy, but it's a drawn out process and extra paperwork. So it's always good to keep and preserve the original will. You should have a list of the family contact information. You're going to have to, in your wills, in your probate proceeding or administration, you're going to have to list who are, remember what I said, the distributees. So you want to know their names, their addresses. You have to do certain things, which I'll get into in a second. So you want to gather the immediate family contact information. You should gather a list of assets and liabilities. So regardless of whether you file as a probate or you file an administration, the fee that you have to pay is based off on how large the estate is. If it's under 50,000, it's a small estate. It's going to cost you $1. If it's over 50,000, there's a sliding scale, and the maximum is 500,000 and above, which currently is about 12,500. So you want to have a list of assets and liabilities, at least an initial list in your initial filing, and then once someone gets appointed, they can continue to look for assets. You want to see if there are any life insurance policies or IRAs. That's an important document and information to gather. It will become important later. You have to understand if there are any pre or post nuptials, because you'll find that in those documents, there's certain clauses and requirements potentially of the deceased, either in a pre or a post nuptial, or the same in divorce paperwork. So if you have someone who has a divorce, you want to look at those documents to make sure there's no continuing obligation of death that the person had with regard to that. You want to gather titles of real estate and vehicles. So you want to see if you can find the deeds. You want to see how it's structured. Is it joint? Is it a right of survivorship? Is it held in some other manner? And the same thing with vehicles. As a quick aside, with vehicles, you can continue to use the vehicle as long as the registration is not expired. Once the vehicle's registration is expired, you really can't drive it around. You can't get a new registration until a fiduciary, an executor, or an administrator is appointed. So I get that question a lot with vehicles. And you should gather the paid funeral receipt. When it comes to making payouts and debts, the court always wants to make sure that the funeral home is paid. It's usually like they get paid off the top. So thankfully, the second is the attorneys. So I'm happy for that. So now you gathered all your documents, and now you start the process. As I said earlier, if there is a will, the person who has the original will gathers the required documents and completes a probate petition. Legalese and devicees and distributees must be given notice. In New York, it's very strict. So if you have a brother or a parent or a child who you don't like and you didn't give anything to, they're going to get a copy of the will. And they're going to be notified of the death, and they're going to be notified that you're starting a probate proceeding. If it's an administration, it's the same thing as for a will, except you're not filing a will. You're just proceeding in that manner, but the notice requirements are still there. The next step is once you file the paperwork, you file the petition and you pay the fees. Then at that point, something happens. The court appoints the fiduciary. Fiduciary could be the executor or the administratrix, either one. It's easiest if all your distributees consent and say, yes, I agree to probate the will and to appoint you as the fiduciary. Then if they do not all do that, then the court issues what they call a citation, and then you have a hearing, and the court will listen to what everyone has to say, determine if the will is valid, or determine if you should or should not be appointed as an executrix or a administrator. So after the proceeding is done, or if everyone consents, then the surrogate appoints the fiduciary. They issue what we call letters of testamentary if it's from a will, or letters of administration if it's for an administrator. The fiduciary has a bunch of different duties. They have to locate and manage the assets and property of the deceased. So they have a lot of power. They can sell property, they can purchase property, they can vote shares, they can do proxies, they can handle brokerage accounts, etc. They also have a duty to identify creditors and debts. So they do have a duty to the creditors and debts to pay that off. So if it's credit card bills or mortgages, they have to work to get that resolved in some way. After they go through locating all the property and getting together and identifying the creditors and the debts, then they have to prepare a formal or an informal accounting. One of the things that the court will not allow you to do is make a complete distribution of the assets for 9 months after the appointment of the fiduciary. And this is to allow those creditors and debtors to show up, because if they're not sending you a letter saying, hey, you owe me money in 9 months, then maybe there's nothing there. So at the end of the day, you prepare a formal or an informal accounting. You want the beneficiaries to agree to that. If they don't agree, you have to go through a formal accounting, which I'll talk about a little bit in a while. And then you have to, as the fiduciary, move to what we call settle the estate, and it's either done on consent, so everyone looks at your informal accounting and says, yeah, that looks right to me, or judicially, if there is a problem or someone does not agree with what transpired during that. And the only people who could agree or disagree are the beneficiaries and the distributees. Like someone who is, a non-relative or someone who's not considered to be a distributee cannot make these challenges. And after the court signs off on everything, they distribute the assets. The executor and the administrator are legally entitled to a commission, and that is based off of the assets, how much you have. There's a formula in the rules that say how much you get paid. If you decide to collect it, then you have ordinary income. So that's soup to nuts, or kind of a bird's eye view of probate proceedings. This is my legal disclaimer that this presentation wasn't intended to advise, but just to inform. Speak to a lawyer about your individual case. This is my contact information. Please feel free to give me a call or shoot me an email. I'd love to talk to you more about it. And thank you very much.